I'm happy to introduce to you Deborah Hofflinger. She's a graduate from John F. Kennedy High School in Paterson, New Jersey. She has a BA and 2 MAs from Montclair State University. She taught social studies and law for many years at Butler High School. She has been a judge for National History Day, a presenter at the Oxford Roundtable in Oxford, England, a grant reviewer for the Department of Education, and a reader for the advanced placement exams. She's been an adjunct professor at the County College of Morris for 10 years. It is my pleasure and honor to introduce my colleague, Deborah Hofflinger.
Thank you very much, Shelley. Let me see. There we go. Come on. There we go. Okay, so I'm gonna share my screen. You can see I have a PowerPoint on Ruth Bader Ginsburg. Let me get it started, and then I'm gonna just say a few introductory things. Come on. All right. I'm having a problem getting to the start the show thing. Shelley, can you see it up there on the top?
If you go to slideshow, click on slideshow.
I can't get, it won't let me do it because it's being covered on the top. That's the problem.
Oh, it's okay. So if you go to the top of your screen, you're seeing the commands. It should let you hide floating meeting controls. Can you get to slideshow now or no?
I still can't because now I'm getting live transcription. Who can see the, wait, let me X that out. Let me exit out. Yep, I got it. Okay, we're good. All right, let's go to slideshow. And from the beginning. And there we go. Okay, so, just let me give you a little background on how I got involved in this. I taught law for a long time at Butler High School with my students, and I really have a lot of interest in constitutional law. And I do some of these presentations like this for some of the local libraries and for the Morris County Community School. And they asked me to do something on women, and women is, the history of women is a big thing for me anyway. And so we picked this, and that's where I got the idea to do this. When I did start to research Ruth Bader Ginsburg, I was really amazed that a lot of the court cases that I had been teaching all these years to my law classes were cases that she had personal involvement with. I mean, I knew the cases and I knew the stories. I didn't know it was her. And so it was really exciting for me to find out how much of an impact she's had on legal issues for women, because that becomes a big focus. And you'll see as we go through this, you'll see very quickly that that's it. The thing that I have up here on this first slide, this is an introduction that was done by the Rutgers University president just this year, last fall, when they named a building after her down at Rutgers. And another thing that makes it really fun for us is that she taught it in New Jersey for so many years at Rutgers University. So she's even a local person as well. So this is what he had to say. He said, she was unafraid to be pointed in her critique of power, especially when it was directed against those without power, who were overlooked by history and who were rendered voiceless by the circumstances of their gender, race, paycheck, language, religion, sexuality, and nationality. And that really, I think, sums up Ginsburg very well. What I'm going to do is give you a little background on her life, and then we're going to dig into some of the cases, okay? Okay, so she was born in Brooklyn, New York. Her parents had both come here from Eastern Europe, which is really kind of apropos considering what's going on right now. And she had an older sister who died at age 6 of spinal meningitis. So she grew up as an only child. Her mother was an outstanding student herself and a bookkeeper. But in those days, it was the son who went to college. And so the family paid for her son to attend, her brother to attend Cornell University. So Ruth's mother never really got the advanced education that she probably would have excelled at and wanted. But that made her mother a really strong advocate for the roles of women. And, she really admired people like Eleanor Roosevelt and Amelia Earhart, and she passed that on to her daughter. And she exposed Ruth to lots and lots of culture, theater. You'll see that Ruth eventually gets very involved with opera. She loved opera. And all of this came to her from her mom. She took piano lessons. Of course, she attended a Hebrew school because the Baders were Jewish. And then in the summer, she went to this place. This is the Camp Chiniwa, which was owned by her aunt and uncle. And it was a camp for kids in the Adirondacks. And at that time period, and I guess they still run some of these today too. At that time period, a lot of city kids would go away, for summer camp. And she, did a lot of athletic stuff there. And she eventually became a camp counselor and, water skiing and all that type of thing. But I think it's also interesting that she commented that this was the first time that she ever saw a sign on the lawn that said, "No dogs or Jews allowed." So at a very young age, she was exposed to the whole idea of discrimination. And of course, living where she did in Brooklyn, there was a large Jewish community, so she didn't really come face to face with that. This is where she went to school. This is PS 238 in Brooklyn. The building is still there. So she went to public school. She was a big reader, and she read 3 or 4 books a week. She was not a math student. Math was not her favorite. I understand completely. But she and her mother expected her to bring home all A's. I think that in many ways, Ruth was achieving the things that her mom never got the opportunity to achieve. She became the co-valedictorian of her elementary school, and she played the cello in the school orchestra. So this was a young woman who had a variety of interests. I mean, my mother would refer to it as, the jack of all trades. Okay. This is a high school picture of her. She attended James Madison High School, 800 students at James Madison High School, and the school was 60% Jewish. So you can see why she was not necessarily exposed early on to discrimination. We were talking today actually in the adjunct office about the fact that, that even today there are like ethnic communities. And back then, particularly in New York, you had Chinatown, you had Little Italy, and, and of course you had Jewish sections as well. An interesting thing for her too, though, was that this was a time period right after the Depression when a lot of faculty who had PhDs had lost their college jobs. And so they were teaching in these high schools. So she had some really, really talented and academic teachers. And of course, she was not just an academic student, she's in these honors classes, but she played in the orchestra, and she was a twirler for the football games. So she was chosen to be one of the few students to speak at graduation of high school. She graduated in 1950. They called it the Round Table Form Honor. But she didn't speak at graduation. In fact, she didn't attend graduation because her mother passed away from cancer just a few days before the ceremony. The school actually delivered her diploma and awards to her house. So she lost her mom, who had been a tremendous influence on her life at a young age. So she got into Cornell. Remember, that was where her uncle had gone to school. And she was able to do it. She got some scholarships. She got, saved her money. Her father really became very depressed after the death of his wife, and his business fell apart. And he ended up, moving out of town and living in a very small apartment out on Long Island. And so it was a really difficult time for him. But it's interesting, the people that she met at Cornell at the time, Vladimir Nabokov was teaching literature classes. And she was also teaching, getting government classes for Clinton Rossiter Robert Cushman. Those of you who don't know it, Cushman and Rossiter are two of the big legal minds at the time. Cushman's books I have on my bookshelf. There are all kinds of things about Supreme Court cases. And she becomes one of Cushman's research associates. And of course, the early 50s is the time of the McCarthy hearings. And so she and Cushman and the other people there got involved in following these McCarthy hearings, the House Un-American Activities Committee. And then she took a class with this fellow, Milton Konowitz, on the idea of American ideals. So she became inspired by all the political activism. There was a lot of things going on at this time period in America over that. And then lo and behold, one of her professors got called to testify by the House Un-American Activities Committee. He was accused of subversive acts. I'm sure you all know that the whole background to that, okay? The idea that there were communists who were in our country and who were trying to subvert our government. And they had these tremendous hunts for people, in academia, because they really thought that a lot of the academics were probably closet communists, and in Hollywood. And if anybody's seen the movie that's out on Lucy Arnaz and Desi Arnaz, that it focuses on that. She was called to that committee to testify too. And there were a lot of people who lost their jobs. I used to always tell my classes that when I first applied for a teaching job in the 70s, one of the questions on several of the applications was, are you now or have you ever been a member of an organization considered subversive by the American government? So that, my comment was, if I was, would I tell them that? I mean, obviously they wouldn't hire me, but that came from that whole time period. So because she was personally acquainted with this professor, the whole school was involved in this, and he was tried and he was convicted. He was given a 4-month suspended sentence because he refused to answer questions about other people. That's what they did on this committee. They brought people in and they asked them to tell them, who else do you know that's doing this? Or, are these people communists? And he actually lost his job without pay for 3 years because of that. So while she was at Cornell, she meets Martin Ginsburg as a freshman. This is a picture of them, okay? And he was also interested in becoming a lawyer. And by the time they were seniors, they knew that they were going to be together. So he was a year ahead of her, and he went to Harvard Law School. And then she graduated Phi Beta Kappa, and they got married. And she was going to go up there to join him at Harvard Law School, but he got drafted into the Army. And in the 1950s, you got drafted and you had to actually spend time in the military. Today, they just ask you to sign up so they know where you are. Right? So instead of going to Harvard, they went to Fort Sill, Oklahoma, which had to be a real change of pace for her. And they're a very interesting married couple for their time period. The 50s was a time period when women were supposed to stay home and raise kids, and the husband was supposed to bring home the money. But they were really equal partners and for their whole life. And they were very supportive of each other throughout their lives. And they shared their child caring duties. They had the daughter when they were out there in Oklahoma. The son was born considerably later. Ruth apparently was a lousy cook. And so as a result, Marty taught himself to cook. And even when she was on the Supreme Court, they would have dinners. It was always Marty, that all the cooking people would come, to the house, and, and he was the host. So finally, when he completed his military service, he went back to Harvard Law School, and she went with him. And I think some of this is kind of interesting. She was one of only 9 women in a class of 500. And women were so unusual there that they had this dinner. One of the deans asked each of the women to stand up and explain why she was at law school taking a seat away from a man. Mentality that we don't really see so much anymore. But when he graduated, he got a position with a firm in New York City. She transferred from Harvard to Columbia Law School for her final year. And she was the only woman editor of the Law Review, and she tied for first place in her class. So you can see that she was an extremely accomplished woman. Of course, even though she was an extremely accomplished woman, all right, it was very hard to get a job because she was a female. In fact, another little factor, Sandra Day O'Connor, who also graduated at the top of her class from Stanford, when she graduated, was offered a job as a law clerk too. Nobody wanted to hire her as an attorney. So it was a time, when they actually put on the job applications on the advertisements in the newspaper, men only. And her comment was she had 3 strikes against her. She was Jewish, she was a woman, and she had a 4-year-old daughter. And the assumption is that you don't work if you have children at home. Okay. But she had some professors who liked her, and admired her abilities. And so she got a position as a law clerk to the trial court judge in one of the U.S. District Courts, Southern District of New York, which has been in the news lately too. And she stayed there for 2 years. And then she worked on a book for a Columbia Law School project on international procedure. So in order to do that, she had to do research, and she went to Sweden, where she learned to speak Swedish. And she found out that in Sweden, 25% of the law students were actually women, unlike what you saw in the United States. And she also read this book called The Second Sex, written by Simone de Beauvoir, that explores the whole problem of gender discrimination. So that becomes a real focus in her life, the idea that women should be treated equally to men. And you'll see that in the cases that she gets into. So when she gets done with that, she actually got hired to teach at Rutgers Law School. She was one of only 2 female professors there. Initially, she was hired to do civil procedure, which are the rules that govern civil lawsuits. But then she had women students, and they started to talk to her about, why can't we talk about women's rights and the way the law treats women? And so she began this seminar called Women's Rights, Sex Discrimination, and the Law. And she began to volunteer with the New Jersey chapter of the American Civil Liberties Union, and she argued cases, and she acted as a negotiator. And she became really interested in a series of cases of New Jersey public school teachers who were forced to leave their jobs in their 4th or 5th month of pregnancy. That was very common back then. The assumption was that when you got to the point where you could see that you were pregnant, you had to leave. You were not allowed to stay. And I have a friend who would tell you that she knew people that, because they would allow the students sometimes to stay. So they would have, some senior who was pregnant, who was obviously pregnant, and they could stay in school, but the teacher had to quit. So there's a couple of cases that she got involved in there. She filed a lawsuit on behalf of one of the gardeners whose son could attend Rutgers tuition free, but his daughter was not eligible at Douglas to attend tuition free. Douglas, of course, at the time was the women's version of Rutgers. And then her argument was, and you'll see that eventually they win this case, that the university, because it's a state university, could not prohibit on the basis of gender. She challenged a summer engineering program at Princeton that was only open to male students. And she advocated for female factory workers who were denied family health benefits because they were female, where the men could get it. So you can see the pattern here. What she's doing is trying to provide women with equal access. And this is the other thing that she did while she was at Rutgers. She co-founded the Women's Rights Project of the ACLU, which is still in existence today. And she also helped to bring this Women's Rights Law Reporter to Rutgers, and it still publishes in Rutgers today. It's the oldest legal periodical in the US that focuses entirely on the field of women's rights law, and she was their first faculty advisor. And they publish, I think I read that they publish twice a year, but they focus on cases that are involved with women. Okay. And then while she was at Rutgers, she had the son. This is a picture of them on the boat, well, the four of them. But she was afraid that if the college found out she was pregnant, that they would fire her. So she hid the fact that she was pregnant until she had signed her contract, so that, you know, they couldn't fire her. You know, so it illuminates, I think, folks, the fact that women always had to worry about that stuff at that time period. Okay. I can remember when I first was married and I got a credit card, and my credit card said, Mrs. Daniel Hofflinger. It didn't have my name on it. Okay. And I took my students one time to a seminar on women's legal rights. And one of the things that they told us at the time was to make sure that we had money that was in our own name. Because if anything, God forbid, happened to your husband, or you decided to get a divorce, you had no financial history, and it would be very hard for you. You know, so these are like little things that we all kind of had to learn during that time period. So then she was offered a position at Columbia Law School. And she was the first female full professor in all the years that Columbia Law School existed. But she arrives at Columbia, okay, she just gets there, and she finds out that the university is about to fire 20 women who were, you know, cleaners. They were mostly Black and Hispanic. They were the cleaning ladies. But at the same time, they were hiring male janitors to do the same jobs. So she was like, whoa, wait a minute. You know, that's gender discrimination. She and the ACLU went after them, and they halted them from firing these women. So by 1980, she starts to become a judge, and she was appointed by President Carter to the U.S. Court of Appeals for the District of Columbia. When Carter took office, he realized that there were only 6 of all those federal judges who were women. And so he went ahead and appointed 40 women as federal judges, and deliberately appointed women as federal judges. So, you know, and it's interesting that, you know, of course, that President Biden has announced that he was going to appoint a woman. And there was a lot of criticism, you know, why would he say that? You know, why would he say, I have to have a woman in this position? Well, Carter did the same thing for just the same reasons. I mean, he's trying to expand the scope of people who are in the judiciary. And then in 1993, when Justice White announced his retirement, President Clinton appointed her to the Supreme Court. At that point, you know, there was just going to be the 2 of them. She was sworn in on August 10th, 1993. She and Ruth, yeah. I'm having a brain warp here. Sandra Day O'Connor. So there was just her and Sandra Day O'Connor on the court. This was not as easy as it sounds, by the way. There was a big background discussion on whether or not they would take her on the court. And there were, you know, all kinds of people who were pro and con. The 2 senators from New York really pushed it because they admired her. Okay, so let's talk about some of the cases that she was involved in. Okay, all right. So this is the case of Norma Simon. She was a woman who had enlisted in the military, and she met a soldier there, and she got married, and they had a child. And then she realized that this was not a good relationship, and she got a divorce, and she put her kid up for adoption. And she decided to re-enlist in the military, and they denied that. But Justice Ginsburg was involved in this, and she was able to re-enter. These are some of the women's rights cases. This is the one I was telling you about with the son who worked for Rutgers. The son could go there for nothing, but the daughter could not. She also argued for this lady here, and I won't even pretend to pronounce her name correctly, who wanted to continue her teaching job, was told that she had to leave through pregnancy, and that became a big focus for her. This is another one. She represented an employee of the Lipton Tea Company who, unlike her male counterparts, could only get group insurance for herself, not her spouse or her children. That was very common, that, you know, there were separate rules for men and for women. And then, of course, the cleaning staff that we talked about already. So let me give you a little background on some of the reasons why the laws were set up that way, okay? Even though women got the right to vote in the 1920s, there were a lot of other areas where women were not equal. And they were held to this old concept, which meant that married women had very few rights of their own. The husband could control your property, your children, okay, your money, even your body. The concept of marital rape did not exist at all. If you got a divorce, which was really frowned upon at that time anyway, but if you got a divorce, the courts almost automatically gave the children to the husband. Okay, and that's really flipped today. I mean, a lot of people argue that that women get preference today more so than men do, but I think it's they're trying to make it more a question of what's the best interest of the child. But back then, that was the kids were considered to be the husband's property. There was also a time period in that the husband could be seen as legally hitting his wife. He could beat her, what they called it the rule of thumb, with anything that was not wider than his thumb. So this is a case that really inspired Ginsburg. It's called Hoyt versus Florida. She killed her husband because it was, domestic abuse. And her attorneys appealed because they said she couldn't have a jury of her peers because women were exempted from the jury. There were no women on the juries. And the Florida Supreme Court agreed with the state, saying that the woman's primary obligation was to her home and her family, so they should not be in the jury box. Okay, and this, of course, is one of the things that inspires Ginsburg. All right, and the argument is that women are the weaker sex; they need to be protected. Okay, this idea of judicial paternalism, which referred to the laws that were designed to safeguard women. And many of these ideas were encompassed into laws. And women, were considered to be a partner, but a lesser partner of their husbands. And the men thought they were doing the right thing. I mean, they thought they were helping people, all right? They were helping women, they were protecting them, big, strong guys, et cetera. But in many cases, they did not. This is a very famous case that I used to teach all the time. The Oregon law had passed a law that did not allow women who were working in factories or laundries to work more than 10 hours a day. So Mr. Mueller got in trouble because he was making his female employees exceed the 10-hour limit. And the case went to the Supreme Court in 1908. And the question was, does the state of Oregon's law regulating women's work hours violate the Privilege and Immunities Clause of the 14th Amendment by forbidding the employment of women for more than 10 hours a day in laundries and factories? Okay, so that's the case, the question that the Supreme Court had to deal with. Obviously, one of the side things of this is, 10 hours a day. I mean, that gives you a window into what was considered to be the work week for people in 1908. But the Supreme Court upheld the conviction. They said the state was right because they said the state had an interest in protecting the reproductive role of women. And so that, working that many hours would be detrimental to them, to their health, and to society at large. They said women are in a class of their own. And this was a belief that permeates a lot of these cases throughout the century. This is another case. I think this is a neat case too. 1948. And remember, that was beginning of the century. Now we're talking 1948. This was another case. The Michigan had passed a law that said women cannot be bartenders unless they were supervised by a man. Okay. So the plaintiff in this case was a widow, and it was her husband's business, and he died. And so she was going to be working at the bar. All right. The law did allow the wife or a daughter of the owner to do the job, was promoted by the male bartenders union. Okay. But the court disagreed with it. They upheld the Michigan law, saying that these people were, they were women. They should not be working alone in a bar because they're not capable of handling. Okay. So this is the area where Ginsburg uses the law. Okay, what she really deals with is something called the 14th Amendment. I'm sure you guys are all aware of the 14th Amendment, but it says there's three basic clauses in the 14th Amendment. Nor shall any state deprive a person of life, liberty, and liberty without due process of law. That's the due process clause, okay? And also the privilege and immunities. And then the biggie, of course, for her is deny to any person within their jurisdiction the equal protection of the laws, equal protection of the laws, okay? Now, that, of course, was originally created to deal with the freed slaves. In the 20th century, it becomes the focus that's used by so many groups in our country to demand equal protection, and women are just one of those groups. So this is the case that really gets her into the national spotlight. Her husband, Marty, she's doing all of this women's rights stuff. He's actually a tax attorney. That's what he did. So he comes home with this case and he says, you ought to read this. And she says, Marty, I don't do tax cases. And he said, come on. So finally she reads it. And then she looks at it and she says, let's take it. And it becomes the template for so many of our other cases. Charles Maritz was a traveling salesman. He had an 89-year-old mother who needed help. And so he hired nurses for her. He tried to take an income tax deduction, okay, based on the fact that he was providing this nurse for his mother. Okay, he was denied that because he had never been married. He was not a married woman. Okay, so the Ginsburgs were convinced Maritz, and it really was not a whole lot of money that he was going to get back, but it was the principle of the thing. They convinced him to appeal it on the basis of discrimination, and they argue that the portion of the tax code violated the Constitution under the 14th Amendment, and that he, like a woman, should get the tax deduction. And the court agreed with him. Okay, so here's Reid versus Reid. This is another case that I used to teach all the time, all right? This was a divorced couple. They had an adopted son. The kid commits suicide, sadly. So Mrs. Reid applied to be the administrator of her son's estate. I can't imagine how much of an estate he could have, actually, but Mr. Reid applied. He says, my wife is too dumb to do the job. And besides, this is a situation that only males should do. It should be preferable to having females, okay? And of course, Ginsburg's argument is that the Idaho law, which allowed this, was a violation of the Constitution, okay? All right. Frontiera versus Richards, another one of my favorite cases. Sharon Frontiera was a lieutenant in the Air Force, and her husband was a Navy veteran. So when he left the Navy, he became a full-time college student, but she was still in the Air Force, okay? So she applied for housing and medical benefits, all right, because her husband was a dependent, okay? Well, they said, no, you can't do that, all right, because only male soldiers can get the dependent benefits, all right? If they wanted to do that, she would have to show that they contributed more than half of her spouse's living expenses, all right? Otherwise, she was not eligible. So they decided to sue once they were assured that, she would not be retaliated against, all right? And of course, Ginsburg saw this as a chance to guarantee military personnel the same compensation as civilians received with the Equal Pay Act in Title IX. And she made the oral argument before the US Supreme Court. She said the 14th Amendment was not aimed just at Blacks, and national origin and alien citizenship had already been made suspect classifications, and sex should also have that designation. By what that means is that there are certain classes that like ring a bell for the courts, that they would look at this much closer because they were in this certain suspect class. And then she concludes with this quote from Sarah Grimpe. You probably know Sarah Grimpe was a big abolitionist. She said, I don't ask any favor for my sex. All I ask of my brethren is that they take their feet off our necks. The court agreed with Frontiera. They said that she should be allowed to get the benefits, but they did not label sex as an area of what they call strict scrutiny. But it does set a precedent for women in the military. And of course, by this point, you're starting to get a lot more women in the military, all right, being career military people. This takes us back to the jury case. Remember the earlier jury case? Finally got 8 justices to agree that putting women on juries constituted a jury of your peers. Justice White says, we think it's no longer tenable to hold that women should be excluded or given automatic exemptions solely on sex. All right, if it were ever the case that women were unqualified to sit on juries, that time has long passed. All right. Of course, I'm sure some people wish that they wouldn't have to serve on juries, but that's another story. All right, here's another case, Stanton versus Stanton. This Utah father was divorced. He stopped paying child support when his daughter turned 18 because the state of Utah only required child support to be paid to sons until they were 21, okay? The Utah Supreme Court said there's a reasonable for the differential. Women mature earlier and marry younger, and therefore men had a greater need for education. Okay. And of course, once again, you got the disparity between the women and the men under the law. All right. I mean, there even was a time when women were considered to be legal adults at 18, yet men were not until 21. And of course, the Supreme Court disagreed with the Utah court on this case. This is a good case too. Stephen Wiesenfeld was left with the care of his infant son when his wife died in childbirth. He was denied survivor benefits by Social Security because those benefits only came to women whose husbands had died. Ginsburg argued that he was being discriminated against because of his sex. Okay, so you can see what she's doing here. She argues for the rights of women, but she also argues for the equal protection of men who were, in this case, being discriminated against as well. The government argued that the law was designed to compensate women due to their inferior position in the marketplace. The decision of the case, and this, of course, is a picture of Mr. Weisenberg and his son. The court rejected the idea of female compensation. They researched and found that the original intent of the statute was to provide for the children, not the mothers. And the fact that all 9 justices saw this, they then agreed with Wiesenhold. And Ginsburg stayed in contact with the Wiesenholds for many years after this case. So then, she had a lot of important cases, and then she finally gets onto the Supreme Court. So these are now cases that she did as a decision on the Supreme Court. I like this case too. This is the United States versus Virginia, 1996. Quote is, better dead than co-ed. Virginia Military Institution, which was established in 1839 as an institution for educating citizen soldiers. They forced them to integrate in 1968, but they did not allow women. So in 1989, a young woman filed the complaint. Case went to the Supreme Court. Ginsburg wrote the majority opinion, which struck down the admissions policy as a violation of the 14th Amendment. Okay, so, you start to see in the late 70s, I would say, and into the 80s, you start to see many of these all male colleges start to integrate and bring women in. All right, and this was one of the last ones to do that. Of course, it's been in the news lately too, over the issue of discrimination against some of their minority students. This is an interesting case too, Olmsted versus LC. This is a 1999 case. These are a couple of women who were disabled. They had been diagnosed with, some problems, and they'd been treated in an institutional setting in Georgia. But then they got a medical opinion that it was okay for them to go out of the institution, put them in a group home somewhere. But the state refused to do that. And so the case went to court, and the Supreme Court decided, and of course, Ginsburg wrote the decision, that it was an unjustified isolation and disability as a form of discrimination under Title II of the American for Disabilities Act. Okay, and this is a time period. Those of you who were here last year and saw us have the program over the idea of disabilities. This is a time period when there was a push now to not discriminate against people who were disabled. which had been going on for a long time. So that's another area where the Equal Protection Clause has been utilized. This, of course, the famous same-sex marriage case. Justice Kennedy wrote the decision saying that these bans violated due process of law for people. Mrs. Ginsburg thought that she should write a concurring opinion, but then because she wanted to do it on equal protection, but she was afraid that it would water down the effect of the majority division, so she just signed on to Justice Kennedy's opinion. Timms versus Indiana. This is getting really up close to our time period. Timms was convicted of dealing drugs and sentenced to 5 years of probation and $1,200 in fines, which he paid. They also confiscated his car, and therefore he couldn't work, okay, when he comes out of prison. So the court ruled that forfeiture of the car constituted excessive fines under the Eighth Amendment. The Eighth Amendment, of course, is the one that talks about no excessive fines, and it also deals with execution, okay? Okay, now some of the most interesting cases, however, of Ruth Bader Ginsburg's time on the court are the dissent cases, all right? I mean, those were the cases where she was in the majority. In this case, she's in the minority. This also very famous case, the Lilly Ledbetter versus Goodyear Tire and Rubber. She argued that women should be given more time to sue their employers over sex discrimination. The case involved the fact that Lilly Ledbetter found out that the male employees were getting paid more than her. And so she decided to sue them. But the decision of the court was that there was a time frame, there was a window of time for her to go in and apply, and she didn't do it soon enough, okay? And so they said, well, that was the procedure and you couldn't do it. And of course, there was, tremendous screaming about it. And as a result of that, the Congress passed the Lilly Ledbetter Fair Pay Act, which was signed into law. And it was relatively common for men to be given higher salaries for doing the exact same job. And even today, folks, the argument is that for every dollar that a guy makes, a woman makes, it used to be like 70 cents. I think it might be up to 80 cents. Gonzalez versus Carhart. This, of course, is the partial birth abortion case, all right? And upheld the Partial Birth Abortion Act, saying that it did not represent an unconstitutional hinge on the right of a woman to get an abortion. Justice Ginsburg dissented. She said the right of a woman to equal protection should be guaranteed, and that there's a lack of exception for health. She said the absence of a health exception burdens whoever is relevant, women who in the judgment of their doctors require an intact D&E because other procedures would place them at health at risk. And, and issue abortion is still a big discussion today, but the big argument here as far as Justice Ginsburg is concerned is that sometimes what happens is a medical procedure, and that that it puts the woman's life at risk. And she felt that there should be an exception for that. And this is a case that's getting a lot of play recently too, Shelby County versus Holder. This was a lawsuit by the state of Alabama asking the court to declare parts of the 1965 Voting Rights Act unconstitutional. It required certain locations that had a history of discrimination in voting to submit changes in voting to a federal court before they went into effect. In other words, there were, particularly in the South, there were places where it was obvious that minorities had been discriminated against in terms of voting, and they didn't want them to vote. And so they were not allowed to make changes unless they got federal approval. The court in this case agreed. They said, you don't need to oversight these people anymore because the age of discrimination is over. And therefore, they should not be monitored, in essence, is what was going on. And of course, Justice Ginsburg disagreed. And she quoted Martin Luther King Jr. and said, "The arc of the moral universe is long, but it bends towards justice if there is a steadfast commitment to see the task through to completion." And you know that right now there are a lot of states in the country who are trying to alter the voting laws. And there's criticism of that, is that it would not be happening if the Supreme Court had not issued this decision in Shelby County. And of course, the Hobby Lobby case, the owners of Hobby Lobby argue that this came after the Obamacare, that they should not have to include contraception to their employees as a part of their health insurance because it violated their religious beliefs, okay? And so the court agreed with the company, saying there were better ways of implementing the Affordable Care Act, but they did not really address the issue of free exercise of religion. Justice Ginsburg wrote a 35-page dissent, and she read part of it from the bench. And she said that until today, religious exemptions had never been extended to any entity operating in the commercial profit-making world, okay? And she said this will deny legions of women who do not hold their employees' beliefs access to contraceptive coverage. Now, I should say that they did come up with a workaround of this, but there's a new case going to the Supreme Court this year involving the whole issue of religious belief exemption to the law. So it'll be interesting to see. You probably know the case of the baker, who didn't want to bake cakes for anybody who was gay. That's another whole thing. The court had held many years ago that if you open your business to the public, then you have to abide by the laws, all right, the anti-discrimination laws. And this is an attempt to alter that with the idea of religious beliefs. So Ginsburg became famous for wearing collars, okay? It said, the robe is made for a man because he has a place for the shirt to show and the tie. So she and Sandra Day O'Connor thought it would be a good idea if they had something typical of a woman. So two of them came up with all these fancy collars. And this is her most famous one. It's her dissent collar, which she wore when she was in the minority. And it became so popular that, people went out and copied it. This is the dissent collar. But these are her many collars. She had lots and lots of collars that she used just to, jazz up the robe. I told you that she became very much an aficionado of opera, and they went frequently to Santa Fe, the opera, for a big August excursion. But one of the people that loved opera too was her fellow Justice Antonin Scalia. That's him on the right there. And it was interesting because Scalia was probably the most different from her in thinking on the court. He was a dyed-in-the-wool conservative. But they had a totally opposite approach, but they still liked each other. They created this opera. Somebody created this opera on their friendship. It was called Scalia and Ginsburg, the opera. And they traveled with the Scalias. They had come to know each other when they were both on the U.S. Appeals Court for the District of Columbia. And the family spent New Year's Eve together and they traveled. This is her and Scalia on an elephant visiting the Far East. So, you can see that you can differ in your views, but you can divorce that from your personal experiences. So her quotes in her dissents were just really amazing, and a lot of young people became interested in them, particularly the Shelby case. And this young law student from NYU created a blog called The Notorious RBG. And it was a reference, of course, to the rapper Biggie Smalls, who was known as the Notorious B.I.G. So she thought it was quite amusing. She said she and Biggie had one thing in common. They were both from Brooklyn. And so there's this industry of all of this jewelry and coffee mugs, Halloween costumes. And she thought it was funny. She ordered these T-shirts and she gave them out to people and encouraged her admirers to fight for good causes. I have a pair of earrings that I'm wearing that are the dissent collar. My daughter gave them to me. And of course, this is her on being imitated on Saturday Night Live. In recent years, there were 2 films created dealing with her. The first is a documentary, RBG, and The Life and Times of Ruth Bader Ginsburg. And it was actually nominated in 2019 for an Oscar. And this was published, this book that was published by the girl who started the blog. And this one, called On the Basis of Sex, came out about 2 years ago too. It was actually written by her nephew. And it focuses on that case I talked about, the Maritz case. And it's presented as one of the building blocks of gender discrimination law. And here it is. Felicity Jones as Ruth Bader Ginsburg. And you can find both of these on some of the streaming sites. One's on Netflix, I think, and the other one is on Amazon Prime. And this is my list of places where you can find stuff. They also did a piece on Sunday morning on her right after she died, I think it was. Okay. Does anybody have questions?
So just a reminder to everyone that if you have any questions, you can put in the chats, or we can unmute you. You will be able to unmute yourself. If you'd like to be able to talk, just let us know. And I already see that we have a question from Professor Soltis. You should be able to unmute yourself.
Hi, Professor Hofflinger, Debbie. Thanks so much for that talk. I really learned a lot. I had a question, it's kind of like to get your opinion on, okay. It seems that the current court is going to undo some past precedents that Justice Ginsburg was involved in, and that might in some ways undo her legacy a bit. And I know when she was alive, she talked about that legislators probably should also protect some of the things that she protected so that future courts wouldn't undo it. I didn't know if you had a comment about that we might be headed in a direction where what you've talked about might be undone.
I think it's pretty well assumed that they're going to overturn Roe versus Wade. To some degree, what they may end up doing is just throwing it back to the states, so that it would depend on what state you live in, whether or not you can legally get an abortion. That could be fixed if Congress would dedicate it into law. The deal, of course, with the Supreme Court cases is that what they're doing is they're determining whether it fits to the Constitution, okay? But if you change the Constitution, I'll go back to something like, for instance, the income tax. The original income tax was declared unconstitutional, but then they wrote an amendment to the Constitution, so it made it okay. So, Congress could do that, okay? But I don't know whether Congress right now would have the motivation to do that. Yeah. It'll be interesting to see.
We have another question. Lais, you should now be able to unmute yourself.
Hi, can you hear me?
I can hear you, Lais.
Great. My question is, so, with the new appointment that Joe Biden made for Ketanji Brown Jackson, do you think that there is space for another revolutionary like RBG, or do you think that the innovations that she was able to make and the progress that she was able to make is, for lack of a better word, the most progress that can be made from one justice at once? Or is there other things legislatively happening in the United States that warrant a similar kind of revolutionary attitude to be taken into account?
Well, I think that putting Justice Jackson on the court is not going to change the court. The court is 5 conservatives and 4 more liberals, okay? And the person who is resigning or who is retiring is one of the liberals. So even though you put a more liberal person on the court, they're still going to be outnumbered. Now, on the other hand, as time goes on, there's always reactions to these things, it'll be interesting to see what the reaction to American society is going to be if the Supreme Court starts to eat away at what they see as, the anti-discrimination stuff. So it's possible that there could be legislation, that would fix this. Or it's not, the argument is that the Supreme Court listens to or watches, what the tone of the time is. And it could be that if they see tremendous pushback by the American population, that they will recognize that and not go as far as they might want to do otherwise. Yeah. Anybody else?
I'm checking the chat. We had some other comments in there, but not necessarily questions.
Yes, one of them says vote in the midterms.
Yeah. And then Anne was also commenting on some of her experiences of back when she was in high school. She told her local vet she wanted to be one too, since she grew up on a farm. And he told her not to do it because it would take the place of a man. And also when pregnant with her first child in 1968, she had to leave her job at the end of her 6 month working in a business office for New Jersey Bell. So some of those specific examples similar to what you were mentioning during the presentation.
I had a couple of those examples. At one point, when my oldest daughter was born, I went back to work. I went back to teaching, and I had people tell me that I would be sorry because she was going to start calling the babysitter mommy. I made a comment at one time about somebody had a job, what it was, and I remember this woman said to me, "Well, it's really sad that she's taking a job away from some man who has to support his family." And I said, you don't know, maybe she has to support her family, but, it was really kind of embedded in people's minds, I think things have changed a lot over the years.
We did get another question in the chat. There's been a recent call from the public to expand the Supreme Court. Do you think this will happen?
No, I don't think it's going to happen. Although I know there's a lot of people who think it would be a good idea. Remember that the court has never been a set number. The court, the number of people on the court has fluctuated over the years. It's only been 9 people, just within our lifetime and a little bit beyond. So, technically they could do that. All right. They can also impeach justices and have them removed from the court. That has been done too. So there, there's been a discussion too about eliminating lifetime appointments. That the Supreme Court, like in New Jersey, people on the Supreme Court in New Jersey have to leave when they reach a certain age. So the argument would be that maybe we should do that with the U.S. Supreme Court also. I don't know. There's a part of me I like the fact that the court is supposedly not listening to political ideas, that they're free to make legal decisions and not being pressured by politics. But on the other hand, recently the court, I think, has become very politicized, so, it might be an answer that we have to look at, once again, it'll be interesting to see what happens.
I don't see any other questions, but I don't want to cut. Oh, Professor Soltis has another one right on cue. Professor Soltis, go ahead.
We're putting you on the spot with these questions, but the answers help us understand the history here. So there's also this idea that if the current court, kind of post Ginsburg, is moving more towards states' rights than federal rights and just letting the states decide, that in some ways that could be kind of interesting, in that liberals and conservative states then would have power. And then you might start to have debates or changing of laws when it comes to, for example, Second Amendment rights and such too. Do you think that's a kind of a big can of worms to return what has been traditionally federal law back to the states? Yeah,
I do. I mean, we tried that once. It was called the Articles of Confederation, and that's why we wrote the Constitution. The issue of states' rights has been an argument since the inception of our country, and there's always those people who argue that the states should have more rights, and those who argue that the federal should. We fought the Civil War to some degree over that. Okay. I mean, obviously the Civil War was actually fought over slavery, but they would say, well, states' rights. Well, why? Because the southern states wanted to have slaves. Okay. But yeah, I don't like the idea of giving everything back to the states, because I think what happens is some people, depending on where you live, are penalized. Take what's going on in Texas right now with the abortion stuff. You can't even go and get an abortion. They're all trying to cross lines, go into Oklahoma, and the clinics there are going crazy. So these states would do that, if they could. And you're right. There's a case coming out of New York State right now over the issue of guns, the right of people to be able to have weapons. These, particularly like New York City has laws against open carry and all that kind of thing. And people in upstate New York are saying, well, we need to be able to do that. And it should be done based on where you live. And, so, yeah, I'm not a real fan of that, but it could happen.
We did have another comment / could be read as a question in the chat from Melissa. I wonder if it would help to simply threaten to stack the court like FDR did to get the New Deal through.
Yeah, well, the problem is that the Democrats don't have enough votes in the Senate. That's the big thing. I mean, it's only 50-50, and so it's really hard. I mean, FDR was lucky; he had a bigger majority there. But that would be an interesting idea. I would just like to think that the court is more neutral. That they look at issues in terms of what the law says and what's the best interest of the majority of the people in this country, and not be their personal ideology that they're putting on other people. I guess I'm an idealist. So.
Okay, thank you very much for the wonderful questions from the audience, and then also to Professor Hofflinger for a fantastic event. As we noted in the beginning, there are upcoming events, and feel free to email legacy@ccm.edu about them. But I'm just going to go ahead and I'll do the reaction and start a clap for Debbie, because that was fantastic. Thank you so much.